Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is January 12th, Wednesday. It's 9:30 a.m. I guess I should mention it's 2022, New Year. Happy New Year, everyone. With us today are Commissioners Emily Lindley and Bobby Janeka and our General Counsel, Mary Smith. I'm John Neerman. Today's meeting is a hybrid meeting, meaning that most of the participants are joining us virtually, so please keep your microphones muted when you're not speaking, and if you're here only to listen, you can watch the agenda online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits, and registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov, and we will do our best to accommodate that request. For those making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking, and please remember to check your microphone before you do speak. With that, I'd like to thank everyone for being present in the room or virtually, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of a motion to overturn the Executive Director's approval of the application by Roadrunner Express LLC for registration number 170067. Each party will have 5 minutes for oral argument and will present in the following order. The movant, Bell County Commissioner Bill Schuman, acting in his individual capacity. The applicant, Roadrunner Express LLC. The ED, and then OPIC. The movant may save time for rebuttal as he bears the burden of proof.
Thank you, Ms. Smith. And I understand that that neither the movement nor the applicant have any remarks that they wish to give to the Commission, but I do want to provide them that opportunity. So, Mr. Schuman, Commissioner Schuman, if you're there, good morning. There you are in the audience. Good morning, sir. How are you?
If it would be possible, I'd like to just save any remarks I have in the form of a rebuttal.
Yes, sir. Yes, sir. Thank you. Is there anyone, probably not in the room, but online, representing the applicant who would like to speak? Okay, hearing none, let's hear from the Executive Director. And if we have...
Good morning, Chairman.
There we go. Good morning.
Can you hear? Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, my name is Clark Reeder of the Environmental Law Division. With me on the line today is Kathy Humphreys of the Environmental Law Division and Charlie Fritz and Megan Hinson of the Waste Permits Division. The Executive Director respectfully requests the Commissioners grant the motion to overturn because Roadrunner Express, LLC, the applicant, failed to provide notice to the county judge as required by 30 Texas Administrative Code Section 328.63D1. This rule requires that an owner or operator of a scrap tire facility shall mail a copy of the notification documents and attachments to the appropriate county judge if the proposed project is to be located within an unincorporated area of a county. The facility is located within an unincorporated area of Bell County, Texas. The applicant provided notice to Henry Garza, the district attorney for Bell County, but failed to provide notice to David Blackburn, the county judge of Bell County. Because the applicant failed to satisfy the requirement to provide notice to the county judge, its application and subsequent registration are deficient. Therefore, the Executive Director respectfully recommends that the Commission grant the motion to overturn and reverse the Executive Director's decision on the registration so that the applicant may have the opportunity to resubmit a complete application with the required notice. Thank you, and we are available to answer any questions.
Thank you. I have none. Colleagues, any questions for staff?
No questions, thanks.
Seeing none, let's hear from OPIC next. Good morning, Mr. McWhirter.
Good morning, Chairman. OPIC recommends granting the motion to overturn and remanding the registration to the Executive Director so it may be properly noticed. We found the notice to be defective because it was not mailed to the county judge as required by Rule 328.63D1. We were also persuaded that applicant did not notify the appropriate local fire authority as required by Chapter 328. There is correspondence from a volunteer fire department that they would respond to emergencies if called, but that doesn't cover all the purposes of Rule 328.63D4. the appropriate local fire authority must be given the opportunity to comment on whether the facility would be in compliance with local requirements regarding fire protection. Because the Bell County Fire Marshal has statutory authority to coordinate a countywide emergency response, we think it would be the appropriate authority to assess whether a facility of this type complies with local requirements and whether the area has sufficient capacity to respond to a potential fire involving 500 to 2,000 tires. So for both of those reasons, OPIC found the notice to be defective, and we recommend granting the motion.
Thank you, Mr. McWhorter. And Mr. Schuman, if you want to offer any remarks, I'll give you this opportunity to do so. And I'm going to ask you to make sure that the green light is on that microphone, and then you can state you can just press where it says push if it's not already on, then just state your name and go ahead with your comments, sir.
My name's Bill Schuman.
I'm not sure and it's the light on the microphone itself.
Okay, my name's Bill Schuman. I'm Bell County Commissioner, and I'm acting in my official capacity and also as an advocate for the taxpayers of Bell County. If I could I bring some packets up to y'all?
Yes, sir. Why don't you hand them to the general counsel, and then she can, right here, Ms. Smith, and she can hand them out.
First, I'd just like to thank you for not allowing this scrap tire facility in the county. I'm not going to bore you with the details of what the county's obligations are for scrap tires, but we spend an inordinate amount of time and money dealing with scrap tires. We also provide the citizens an opportunity to recycle scrap tires, and in the past couple of years have added the opportunity for them to get rid of their large ag tires, again, at a considerable cost to the county. What I have presented or given to you are two of the issues that we're dealing with currently. One of them is not in my precinct, so I'm not as familiar with all of the correspondence, but I know that TCEQ has been involved on that one facility on Pat Cole Road, and basically the county was told, you take care of it. The other one is a TCEQ investigation, I believe, from 1993, so it really was TNRCC. Again, where TCEQ came in, the person that was running the scrap tire facility was fined, and so for all intents and purposes, for everything that we knew, that money was to be set aside for reclamation and cleanup of that project. The pictures that are attached to that show that that has not been done. The current landowner is asking that the county clean it up, since the state has already collected the money for cleanup and has not done it.
And Mr. Schuman, we're getting a little bit outside the matter that's noticed for us today, which is, your motion to overturn this action. So let's keep it focused on that.
Okay.
On that action.
Then let's go back to the application if we can. Certainly, as was pointed out, the notification was not correct. Again, when we go back to the taxpayer and the cost of the taxpayer, we have a public health district at the taxpayer's expense, and we have a major movement to do vector control on specifically mosquitoes and rodents. Mm-hmm. And when I look at the application here, it says that there will be every 2-week application to take care of these vector controls. I'm asking who, on all of the parameters that you put on here of how many tires, how many have to be covered, the vector control, and where this is located in a relatively remote part of the county, who is going to do that enforcement? Who's going to make sure that there's only 500 tires that are not covered? Who's going to make sure that there's less than 5 tons of covered material?
Yeah, and Mr. Schuman, I'm taking your comments, and we may elect to respond to them, but we're not going to engage in a question and answer session.
Understand, and my only point here again is to express my gratitude as poorly as that may seem. At not, and again, go a little bit of history. I've been on the court now for over 9 years, and this is the first application I've seen come through. I didn't even know there was a formal application, because every scrap tire facility we deal with, we assume that the state doesn't know about. So this was a learning experience for me. But again, in future considerations, I just hope that you'll take some of these things into consideration when they're well outside of any municipality or jurisdiction that has the capability to do what you're asking the applicant to do. Thank you again very much.
Yeah, thank you, sir. Colleagues, any questions or comments for Mr. Schuman? Okay. Well, in terms of the matter before us, I think it's very clear that the notice was defective and that we should grant this MTO. That's my view. To respond to Mr. Schuman's concerns, scrap tires are a major environmental challenge, no question about it. Our agency has jurisdiction. There are other local governments that have some jurisdiction over that as well. And specific to any particular concerns where it's suspected that somebody is acting without authorization or is acting outside of their authorization, our regional office is probably in the best position to respond to that. I think that's about all I have to say on those points this morning. Commissioner Lindley, any comments or reactions?
No additional comments. I'm in agreement that we should grant the MTO today.
Commissioner Janeka?
Likewise, I appreciate the request that brought this to Commission's attention. I'm ready to move forward as well.
And Mr. Schuman, thank you again for being here this morning. We appreciate it. And I think with that, colleagues, we're ready for a motion.
I would move that we grant the motion to overturn filed by Bill Schuman on November 8th, 2021, to overturn the Executive Director's issuance of MSW registration number 170067 to Roadrunner Express LLC and remand the matter to the Executive Director for resubmission of a complete registration application, including the required notice.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 2 is the application by Steven Sellinger for new TPDES permit number WQ001-5932001. The parties have been notified that the commissioners will not take oral argument but may ask questions.
Thank you, Ms. Smith. And for the benefit of those who aren't familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has met those requirements, we then consider which issues are appropriate to refer to hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Governmental entities can be granted a hearing if they also have statutory authority or another interest in the issues relevant to the application. And colleagues, on this item we have 5 requests, including 3 from local governments. And beginning with Gregory Burdett's request, he raises 2 concerns, economic harm as well as erosion. And both of those are outside the Commission's jurisdiction on a discharge application. And while these concerns are certainly understandable, neither are legally relevant and material to this permit. So my view is that we're compelled to deny his request. Representative Elzey raises concerns that are relevant and material to the permit. They would be within our jurisdiction, but he has not stated how he is personally affected by the draft permit. So to put that in different words, he hasn't shown that he will be affected in a manner different from the general public. So I think we're also compelled to deny his request. As for the city of Ennis, the proposed facility would be within the city's extraterritorial jurisdiction. The city has specific authority to protect public health, and to regulate development, among other powers. The city has raised concerns about regionalization and water quality, which are relevant and material to this application. Its comments and requests for a hearing are timely, and it has met the other procedural and substantive requirements to be granted a hearing, so I would grant its request. The city of Waxahachie similarly raised relevant material issues, including impacts to Lake Bardwell. But colleagues, I do not view Waxahachie as having a personal justiciable issue because of the relatively modest volume of discharge that would come from this facility and the distance between the discharge point and the lake. So I do not see the city of Waxahachie as being affected in a manner different than the general public. So I would deny that request. I think that's consistent with where we've landed on similar requests, historic requests. And then finally, Ellis County has demonstrated that it has statutory authority to inspect public waters, to assess water quality, and to determine whether wastewater dischargers are operating in compliance with their permits, again, among other relevant authority. And the county has raised relevant and material concerns, including, for example, regionalization and water quality, and it has met the other procedural and substantive requirements to be granted a hearing. So I would grant its request. So just to sum up, I would grant for the city of Ennis and Ellis County and deny the remaining requests. And let me pause there and see how y'all came out.
I'm in agreement.
I arrived at the same conclusion.
All right. I've identified the following referable issues: whether there is a need for the facility as expressed in Texas Water Code, section 26.0282, whether the draft permit is consistent with the policy to promote regionalization under Texas Water Code, section 26.081, whether it is protective of water quality and uses of the receiving waters, and whether it contains adequate operator licensing requirements. And I would refer those both to SOA as well as to ADR. Mm-hmm. And Commissioner Lindley, what do you think?
I'm in agreement on the issues and the referral to ADR. Yes.
Likewise.
All right. I believe we're about ready for a motion.
I'll attempt to capture all of it. I would move that we grant the hearing requests of the city of Ennis and Ellis County, that we deny the remaining hearing requests, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling process, or with the SOA preliminary hearing scheduling process. Excuse me. That we refer the application to SOA for a contested case hearing on the following issues. Issue number 1, whether the permit should be denied or altered in consideration of the need for the facility in accordance with Texas Water Code, section 26.0282, and the general policy to promote regional or area-wide systems under Texas Water Code, chapter 26.081. Issue 2, that whether the draft permit is protective of water quality in the existing uses of the receiving waters in accordance with applicable Texas surface water quality standards. And issue 3, whether the draft permit provides adequate licensing requirements for the operator of the facility in accordance with 30 Texas Administrative Code, Chapter 30, Subchapter J, wastewater operators and operations companies. And, almost forgot, that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item 3 is the application by Studio Estates LLC for Texas Pollutant Discharge Elimination System Permit number WQ001-593-3001. The parties have been notified that the commissioners will not take oral argument but may ask questions.
So again, we have a two-part analysis. Part 1 is about who gets a hearing, and Part 2 is about which issues are referred. And again, governmental entities can be granted a hearing if they also have a statutory authority or other interest in the issues relevant to the application. And colleagues, we have a single request on this item from the Guadalupe Blanco River Authority The proposed discharge will be within GBRA's district, and GBRA has statutory authority to assess water quality and whether wastewater discharges are in compliance with TCEQ requirements. I believe GBRA has shown a personal justiciable interest different from the interests of the general public and has met the other procedural and substantive requirements to be entitled to a hearing. So I would grant its request.
I agree.
I'm in agreement.
All right. GBRA expressed concern about whether the draft permit is protective of water quality in the receiving waters. So I would refer that issue again both to SOA and to ADR, and I would allow 180 days for the hearing.
Yeah, I thought about maybe trying to shorten it, but I'm okay with 180 days. That's fine. I'm good with everything else.
Likewise, I'll try to plow forth with a motion. I move that we grant the hearing request of Guadalupe Blanco River Authority, that we refer the matter to SOA for a contested case hearing on the following issue: whether the proposed effluent limitations contained in the draft permit are adequately protective of water quality in the receiving waters, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, and that we specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
The next item is the application by Ameritex Pipe and Products LLC for issuance of air quality standard permit for concrete batch plant, registration number 164317. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So another hearing request, and once again, we have a two-part analysis. And for concrete batch plants, the legislature has created an additional requirement, which is in the Texas Clean Air Act. It provides that only those persons actually residing within 440 yards of the proposed plant may request a hearing as an affected person. And colleagues, we have multiple requests on this item. However, it's pretty clear to me that none are within the 440 yards of the proposed plant. So it's my view that we need to deny all of the requests.
I'm in agreement.
Likewise.
All right, I believe we're ready for a motion.
I will move that we deny all hearing requests, that we issue registration number 164317 to Ameritex Pipe and Products LLC as recommended by the executive director, and adopt the executive director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 5 is the consideration to affirm, modify, or set aside the emergency order renewing the appointment of a temporary manager for 4 public water systems owned and operated by the estate of Marion J. Smith. The ED should speak first as the movement, followed by the respondent, Ms. Marjanelle Smith, executor of the estate of Marion J. Smith, and I don't believe she's present or online. Hearing requesters, presently, no one has signed in on this. Intermediary Solutions Holdings LLC, the temporary manager, also, I believe, not present. And then OPIC. OGC recommends a 5-minute time limit on each party's presentation.
Thank you, Ms. Smith. I understand we have Mr. Worms for the executive director. Good morning.
Good morning. Can you hear me?
Loud and clear.
Great. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Benjamin Worms, and I'm an attorney with the Litigation Division representing the Executive Director. With me today is Taylor Pearson, also with the Litigation Division, Dorothy Young with the Water Supply Division, and Jason Lindeman of the Lubbock Regional Office. Item number 5 is the emergency order renewing the appointment of a temporary manager of the 4 water systems owned by the estate of Marion J. Smith. The 4 water systems are Town North Village, Plot Acres, Cox Addition, and Town North Estates. All 4 water systems are under a single certificate of convenience and necessity, number 11168, and total 296 service connections. On April 20th, 2021, the TCEQ Lubbock Regional Office received numerous complaints of a water outage at Town North Village, and the customers had been unable to get in contact with anyone representing the utility in weeks. That evening, a TCEQ investigator confirmed that there was a water outage at Town North Village, documenting that there was no water pressure at the system. The investigator determined that the outage was caused when electric power was shut off to the system due to non-payment of electric bills. On April 22nd, 2021, a TCEQ investigator conducted investigations at all 4 water systems and documented that at Town North Village, Plot Acres, and Town North Estates, there was insufficient disinfectant residual in the distribution system, and that a licensed operator could not be identified at any of the systems. The Lubbock Regional Office investigated the situation and found that the CCN holder and listed owner and operator of the utility, Marion J. Smith, had passed away in January of 2021. Investigators also found that at the time of Marion Smith's death, the utility was being operated by Jimmy Midkiff. Subsequently, during the spring of 2021, Mr. Midkiff suffered a severe medical emergency, causing him to cease operating the utility completely, leaving the utility without anyone to conduct basic maintenance and operation of the water systems. Given these risks, the utility was determined to be abandoned, creating a substantial risk of imminent water outages and posing health hazards to the 750 customers served by the utility. On May 5th, 2021, the executive director issued an emergency order appointing Intermediary Solutions Holdings, LLC, as temporary manager for an initial term of 180 days. During their first term as temporary manager, Intermediary Solutions installed new self-contained chlorination systems at all 4 water systems and started maintaining a minimum disinfectant residual throughout the distribution system. They also made various repairs necessary for the maintenance of the system and repaired problems that had developed during the time the utility was abandoned. The utility is now providing continuous and adequate service to the customers, and Intermediary Solutions is working towards becoming the long-term owner and operator of these water systems. The executive director respectfully requests you affirm the November 2nd, 2021 emergency order renewing the appointment of Intermediary Solutions as temporary manager. We are available to answer any questions you may have.
Thank you, Mr. Worms. I have none. Commissioner Lindley, any questions?
No?
Commissioner Janeka?
None, thanks.
All right. I don't think we have anybody for the respondent on the line, but let me pause and offer that opportunity for anybody who wishes to speak on behalf of the respondent. Hearing none. I also don't believe there's anybody, any interested persons or hearing requesters wishing to speak, but let me pause and give you an opportunity if there is anybody on the line that would wish to speak. All right, hearing none. Same goes for the temporary manager. If there's anybody with Intermediary Solutions who would like to address the commission, this is your opportunity. All right, Mr. McWhirter, I know you're there. Good morning again.
Good morning. OPIC recommends that the Commission affirm the Executive Director's November 2nd, 2021 emergency order renewing the appointment of Intermediary Solutions Holdings, LLC, as temporary manager of the 4 public water systems owned by the estate of Marion J. Smith. We support approval of the proposed order presented by the Executive Director.
Thank you, Mr. McWhirter. And I'd like to begin by thanking Intermediary Solutions for stepping in and operating these abandoned systems while we search for a more durable solution. And colleagues, I don't have any reason to do anything other than move forward with this emergency order and approve of it.
I agree.
Likewise, I'd only add, I'm pleased to see that there's reports of new chlorination systems installed. Continuous service has been demonstrated out to the users. I'm pleased to see that, and I hope to see further promising progress reports on this. And in that direction, I'll move that we affirm the Executive Director's November 2nd, 2021 emergency order renewing the appointment of Intermediary Solutions Holdings, LLC, as temporary manager for the water utility owned and operated by the estate of Marion J. Smith, and issue an order approving the Executive Director's emergency order.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next items.
That brings us to our enforcement docket, items 6 through 30. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 30. The total assessed administrative penalties are $499,939, with $60,214 deferred, $126,027 applied for supplemental environmental projects, and $313,698 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley?
No.
Commissioner Janeka?
None, thank you.
Is there any, Ms. Smith, is anybody signed in to speak on any of the enforcement items?
We have people who signed in but said they did not wish to address the commission unless asked, and that's on items 6, 7, 8, and 21. But no one is signed in who asked to address the commission.
Okay, appreciate that. Mr. McWhorter, what's your assessment?
My office reviewed these items and we recommend approval of the orders as presented by the Executive Director.
Thank you, Mr. McWhorter. I agree. Colleagues, I've reviewed these items and think it's appropriate to move forward with them.
I agree with that. I would move that we adopt items 6 through 30 as recommended today by the Executive Director.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 31 is the consideration for the publication of and hearing on the proposed amendment to 30 Texas Administrative Code, Section 114.622, and corresponding revisions to the state implementation plan. The Executive Director's staff is here to present this item.
Good morning, Mr. Hickman.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. Excuse me. On behalf of the Executive Director, I am Nate Hickman with the Air Grants Division. With me online is Sierra Redding of the Environmental Law Division. This proposed rulemaking would amend Chapter 114, Control of Air Pollution from Motor Vehicles Mobile Source Incentive Programs, Diesel Emissions Reduction Incentive Program for on-road and non-road vehicles, Section 114.662, as amended by House Bill 4472. The adopted amendments will be submitted to the United States Environmental Protection Agency as revisions to the state implementation plan. HB 4472 did authorize the TCEQ to set the minimum usage in area for a diesel emission reduction incentive grant for marine vessels at 55%. And this is consistent with the minimum authorized for the other on-road and non-road vehicle types under this program. A public hearing will be offered on this proposal on February 18th, 2022. And staff respectfully recommends approval to propose the publication of and hearing on February 18th, 2022, Chapter 114, Control of Air Pollution from Motor Vehicles. Staff also respectfully requests permission to make non-substantive revisions to comply with the Texas Register requirements. Thank you, and we are available to answer any questions you have.
Thank you, Mr. Hickman. I have none. Commissioner Lindley, any questions?
No, thank you.
Commissioner Janeka?
I can't help but ask while I have the topic teed up in front of us, and I've keyed in on that minimum threshold. The 55% number is a magic one I've seen elsewhere under TURP requirements, and I just wondered if you could speak a little bit about that policy lever. How does reducing that or setting the minimum, how does that mechanism tend to work? Do we expect that we might have more applicants from this, and is this a conversation that you expect the regulated community may want to continue advocating for?
Thank you, and you're correct. The expected impact is that this would expand the population of potential applicants for the Texas Emission Reduction Plan grants. Generally, we look for projects, if you look at this current rule proposal, marine vessels operating in and around key areas of the state like the Houston Ship Channel Port of Houston, We're looking for those older pieces of equipment with large diesel engines that are operating a good percentage of their total usage in that area, so that when we offer grants to help replace those with newer, cleaner burning engines or marine vessels, we're taking a significant portion of those emissions out of that area. Previously, we had set that at 75%, which was a goodly portion. However, we do understand that there is a wider variety of equipment out there moving along the Texas coastline, just like the equipment within the Texas non-attainment areas on land, that is still a significant portion of usage in these areas, but less than that 75%. So we understood that we could, and the legislatures foresaw that we could possibly achieve even greater emissions reductions by expanding that population through allowing a slightly lower percentage of usage in that area than previously required.
I appreciate that response. It confirms what my layman's understanding of that mechanism is, and I hope that as the legislature, our agency, the regulated community in turn, continues to address all of the low-hanging fruit of available and eligible vehicles that meet the economic criteria and now programmatic criteria, I hope that we continue to see more opportunities for progress to make. But thank you for this making real matter here. Other questions?
Great. Has anyone signed in to speak, Ms. Smith?
No one is signed in on this one.
Okay, and how about OPIC? Mr. McWhirter?
OPIC recommends approval for publication of and hearing on the proposed amendment to Commission Rule 114.622 and corresponding SIP provisions. The rulemaking is needed to implement House Bill 4472. We support publication of the proposal as presented by the Executive Director.
Thank you, Mr. McWhirter. And colleagues, I can't help myself, but so much of what we do, pretty much everything we do, is just, it just reeks of kind of bureaucracy and technical terms and is not very accessible. And I think I have the sense that the only people who watch these agendas are people who are tuned into the technical speak and the bureaucratic process. And so maybe this is not of great value, but I just want to provide a little bit of context for TURP and what it is. And just at a very high level, the state lacks the authority to regulate mobile emissions. And so the legislature has created a grant program, a voluntary program that allows us, in its simplest form, to spend monies to replace dirty diesel engines with some sort of cleaner power plant to reduce mobile emissions. And mobile emissions are the biggest air quality challenge in most of our major metropolitan areas. So for a little bit of context, for anybody who may be watching who's not sensitive to what TURP is all about, it's the state's voluntary effort to try to get a handle on our air quality where we lack that regulatory authority by statute. So thanks for indulging me in that explanation. I'm ready to put this out for comment. I think we're ready for a motion.
Thank you for bringing us back to reality and
Yeah.
giving a little layman's explanation of what that is. I will make the motion that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Section 114.622, and corresponding revisions to the state implementation plan as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 32 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 335, regarding industrial solid waste and municipal hazardous waste. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jarita Sepulvedo with the Waste Permits Division. With me is Diane Goss with the Environmental Law Division. This adopted rulemaking amends Chapter 335, Industrial Solid Waste and Municipal Hazardous Waste, to revise state industrial solid waste and hazardous waste management regulations to maintain equivalency with Resource Conservation and Recovery Act revisions promulgated by the United States Environmental Protection Agency and to formalize the foundry sands exclusion. The proposed rules were published in the July 30th, 2021 issue of the Texas Register. A virtual public hearing was held on August 23rd, 2021, and the public comment period closed on August 30th, 2021. The rule team made no substantive changes in response to public comments received. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 335. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Sepulvedo. I have none. Commissioner Lindley, any questions?
No questions, thanks.
Commissioner Janeka?
None.
Ms. Smith, has anyone signed in to speak?
No one is registered on this item.
And Mr. McWhirter, what is your assessment?
OPIC recommends adoption of the proposed amendments to the Commission's Chapter 335 rules as presented by the Executive Director.
Thank you. Colleagues, this subject matter may be hopelessly bureaucratic, so I'm not going to try to put this one in context. But I will say that these amendments are designed to keep us in step with EPA requirements so that we can maintain delegation, and I think we should adopt it.
I would agree. I think we got a good amount of comments. They seem to be substantive, and I think staff, made changes where appropriate. And I'm encouraged to see that they plan on working on guidance documents and those kind of things to help further, hopefully make it easier for the regulated entities and those that are interested in this topic, and in general, to make sure that they're following the rules appropriately and that kind of thing. So I know there's more work to come on it, but I'm good moving forward with it today.
Commissioner Janeka?
Very well said. I appreciate as well all the number of commenters. I think it represented a good slice of different interests and concerns about this rulemaking. I was pleased to see some of the changes that helped us clarify our rulemaking, improve the process, and perfect it. But short of those, the clarifications, explanations from the Executive Director on those responses to those comments, I think was very, very helpful to improve the product. I'm ready to move forward as well. I can make that motion. I move that we adopt amendments to 30 Texas Administrative Code, Chapter 332, composting, as recommended.
Oh, wrong item.
335.
Thank you. Pulling back on my notes. I move that we adopt the adoption of the amendments to 30 Texas Administrative Code, Chapter 335, Industrial Solid Waste and Municipal Hazardous Waste, as recommended by the Executive Director.
I second. Oh,
I'm sorry, did you say adopt the adoption or approve the adoption?
Approve the.
Okay,
I will
just
try
wanted
that
to clarify.
final time.
Cut from the top.
I move that we approve the adoption of the amendments to 30 Texas Administrative Code, Chapter 335, Industrial Solid Waste and Municipal Hazardous Waste, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 33 is the adoption of amendments to various sections of Chapter 332 of 30 Texas Administrative Code, Chapter 332, regarding composting. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Adam Schnurger with the Waste Permits Division. With me is Maddie Isteries with the Environmental Law Division and Chance Gooden with the Waste Permits Division. For your consideration today are the Executive Director's adopted revisions to 30 Texas Administrative Code, Chapter 332. The adopted rulemaking will clarify and update existing notice language, add existing language that applies to composting, and make substantive and non-substantive revisions to bring the chapter more up to date with agency and program standards. The adopted rulemaking also includes revisions to clarify landowner notification requirements based on comments from the Office of Public Interest Counsel. These revisions expand the use of map boundaries and specific property owner notification and verification requirements. The proposed rules were published in the July 30th, 2021 issue of the Texas Register. A public hearing was held on August 23rd, 2021. The public comment period closed on August 30th, 2021. Staff respectfully recommends adoption of this rulemaking. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Schnurger. I have none. Commissioner Lindley, any questions?
No, thank you.
Commissioner Janeka?
None.
Ms. Smith, has anyone signed in to speak?
No.
And Mr. McWhirter, what do you think?
OPIC supports adoption of the proposed amendments to the Commission's Chapter 332 rules. The Executive Director staff reached out to me frequently during the process of reviewing and addressing OPIC's comments, and I just wanted to acknowledge and thank them for those efforts. OPIC supports the proposal before you, and we recommend adoption.
Thank you. Appreciate those comments. I think this is a well-considered amendment. We're certainly resolving some ambiguity we had encountered in the notice provisions and making some other corrections and clarifications and updating. I think we're ready for adoption.
I would agree. I would move that we, adopt amendments to 30 Texas Administrative Code, Chapter 332, composting, as recommended by the Executive Director in his revised backup dated December 30th, 2021.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
The next item is our public comment session. We currently don't have anyone signed in to speak or here in the audience, but we can unmute the line for a moment to see if anyone wants to address the commission.
Is there anyone on the line who would like to address the commission? All right, hearing none, why don't we go ahead and call the next items.
The next items are 35 through 38, and they are for executive session. The commission will not meet in executive session today.
With that, the time is 10:16 and we are adjourned.